determine what the law requires of those specific disputes. Now, what our Judicial Code of Conduct requires is that judges remain impartial, and that we as judges and judicial candidates, if they're not judges, in the course of a campaign, not say anything about an issue that could possibly come before the court that would signal how that judge or judicial candidate might rule on the issue if it were to come in front of the court. We are running for a 10-year seat on our Wisconsin Supreme Court, and the issues that could possibly come before the court over the next 10 years are enormous in number. And it is inappropriate for a candidate for the judicial office, much less a sitting judge, to be articulating what specific types of gun control or other safety measures they think are lawful or appropriate. It is not the role of the judiciary to make those determinations. Now, as a parent, do I want to see our schools safe? Absolutely, of course. And I believe my opponent when she expresses her concern about her children's safety and about the safety of their fellow students. But it is not the role of the judicial branch to determine what those policies will be. It is only the role of the judicial branch to determine legal disputes that come before the court.
Question for Judge Screnock first. If elected, will you go to partisan state conventions and other events of either the Republican or Democratic Party?
I have been elected. I'm a judge now, and our rules require one thing and they allow something else. They require that you not be actively engaged in partisan activities. They allow candidates to appear at partisan events for the purpose of advancing their own campaign, and that makes sense. And so if I'm privileged enough to be elected to the Wisconsin Supreme Court for a 10-year term, any participation at any of those events would be solely for the purpose of advancing my next campaign. And I've not been a member of the Republican Party in the past. I've not been engaged in any, I haven't attended any partisan events as I sat on the Sauk County Circuit Court bench until I started going where people were congregating in the context of this campaign. Because again, the touchstone of our judicial branch is that we have an impartial judiciary. People must know that the justices on our Supreme Court will simply interpret and apply the law as they find it, and will not be advocating for policy issues that they want to see advanced. And it's important because our community and our society needs stability, and they need predictability in the law. We do not have stability or predictability in the law when we have 4 justices on our Supreme Court who feel empowered to change the law at their whim because they want to advance some policy initiative from the bench. And that's why I have the endorsement of over 2/3 of the Wisconsin sheriffs, because they know that their law enforcement officers cannot do their jobs if they are always looking over their shoulders, wondering when the Supreme Court is going to change the law out from under their feet at the whim of 4 justices. It's why I've been endorsed by the business community, including the Wisconsin Realtors Association, the Wisconsin Restaurant Association, the Wisconsin Dairy Business Association. These groups and individuals know we need stability and predictability in the law, and that's what we get when we have justices that will simply interpret and apply the law as they find it.
Judge Dallet, please.
My opponent talks a lot about remaining impartial and not taking positions on issues that could come in front of the court, yet the NRA is sending out material on his behalf stating that he has vowed to protect the firearms freedoms that they hold as part of their agenda. And that's what they're saying he has vowed to do. Last I checked, a vow is a promise. I think we all know that in this room, and that is what my opponent has done. He's made a promise to the NRA in order to get their support. He's also endorsed by other groups. I'm not sure what kind of promises he's made to them. Pro-Life Wisconsin, which stands for the proposition that birth control should be eliminated, and another group whose name I frequently forget that is against marriage equality, which is the law of the land. I don't know what kind of promises he made to them, but certainly promises have been made. He also states that he's not actively engaged in partisan activities. Again, the Republican Party has done quite a lot for his campaign. I've seen the billboards they've taken out that are trying to smear me, and I've seen the literature that they have put out that is an in-kind contribution, and so are those billboards, by the way. They say on there, in-kind contribution to Judge Michael Screnock. So he's accepted hundreds of thousands of dollars from the Republican Party. He sent out a flyer with his arms around the governor stating that he was a conservative judge. That's the kind of response that he's given. That's the kind of statements that he's made in this race. I'm the one that has appeared in front of groups across the state in a way that my opponent has not. He's avoided Dane County. I go in front of all kinds of groups, the bar associations, the chambers of commerce, all kinds of groups. I think our race includes really all of the people of our state, not just a select few. And that's what our next justice will represent, all of the people of our state. And I have support from people all over our state of all different backgrounds, including over 200 judges throughout our state.
Question for Judge Dallet. If the court is deciding which cases to hear, and scheduling oral arguments, and deciding cases, and administering the court system, how important is collegiality, Your Honor?
I think collegiality is very important. This is our state's highest court. They are the example to the rest of us. And when you have us making the news in Wisconsin about justices choking other justices, that's a real problem. It should be a problem, one that we should recognize, and there needs to be collegiality on that court. I have worked in our courts for more than 20 years. I served as our first female presiding court commissioner in Milwaukee County, supervising 10 other court commissioners who had been there a heck of a lot longer than me. Able to work with them to really benefit the community and our court system. And now as a judge working with the people that appear in front of me every day in all the cases that I've handled, I know how to get along with people. You do not have to agree with everything someone says in order to make sure that you get along with them and that you're congenial. And that is a big part of what our next Supreme Court justice needs to be. Again, I am the only one here who really has support across the aisle in our state, who is not just appearing in front of one group that has one message. And I think that's important too, to establishing getting along and making sure that people are independent and fair, as opposed to being the next rubber stamp for our governor or our legislature like my opponent will be.
Judge Screnock?
Collegiality on the court is really important. It's important whenever you're part of a body that you're able to get along with the other members of that body. I have lots of experience doing that. I worked in local government for nearly 12 years, and if you know local government, most of the work that's done in local government is done by committees and by groups, and you can't get anything done if you're not able to work with people. I began on the circuit court in Sauk County and came into a situation where there had been tremendous stability in the court, and it was really a goal of mine to make sure that I continued to work with the judges that were there, to learn from them and to understand how they can how I can fit in and do the work that they're doing. That's what I would do if I'm privileged to serve on the Wisconsin Supreme Court. My opponent talks about the importance of collegiality, but once again, her actions don't match her words. So again, she can talk the talk, but she can't walk the walk. She has spent the last 9 months of this campaign urging citizens all across the state to disrespect our state's highest court. She has called it a broken court. She has called it a court that is bought and paid for. She has called it a court that is beholden to special interests. And when asked last week, I believe it was, how it was that she would work on the Supreme Court and whether she could be collegial, she used her experience as a parent as a reason why she would be able to work well with them. So essentially what she has said is that the justices on our Supreme Court are children who need an authoritarian figure to help clean up the mess. Now, I do not know how anybody in this state can think that my opponent could then join that group and be able to work well with them, at least initially, without first repairing a tremendous amount of damage that she has done to their reputation as an institution, and the disparaging remarks she has made directed specifically at a majority of justices on that court.
Next question for Judge Screnock. Do you support the concept of civil Gideon, the idea that the low income should have a right to an attorney when faced with child support, custody, and evictions, civil actions?
It's been clear for me, to me from my work on the bench, that every litigant would benefit from having an attorney. We often have pro se individuals, that is, individuals come in front of the court that don't have an attorney, and they're trying to go it alone, and it's clear that they would all benefit from having an attorney. The question of whether that ought to be granted as a right is a question for the legislature. It's also a funding question. If we're going to be providing attorneys at public expense for civil litigants, then the money needs to be there to pay for those. And the court doesn't make those funding decisions. The court doesn't make those policy decisions. Those are questions for our legislature and our governor, and for, quite frankly, county boards and local officials as to whether or not they have the resources to provide that. So this is a question that gets to the differing roles between our three political branches, that our system of government is set up so that we have two political branches, the legislative branch and the executive branch, and they set policy for the state. And they set policy for the state by passing laws, and those laws come to the court in two forms of questions. First question is, what does the law mean? We know what the law means based on the language and the words that the legislature chose when they put the law in place. We don't look behind the words of the statute to try to divine what we think the legislature was trying to accomplish, but they didn't actually accomplish with their words. The second question that the court has asked is whether or not one of those two political branches have overstepped a constitutional boundary. And I absolutely believe that when the answer is yes, and when they have exceeded a constitutional boundary, the court has a solemn duty to rein in government and say you've gone too far. But when the answer is no, and the political branches have stayed inside the constitutional boundaries, the court has absolutely no business vetoing those policy choices and changing the law to fit the whims of our justices.
Judge Dallet, please.
As for civil Gideon, yes, I believe that we should be providing attorneys for individuals in our courtrooms. I've worked in our courts for 23 years. I've seen how difficult it is to navigate, and I've had jury trials with pro se individuals, both criminal and civil, and seen the challenges that they face, people that can't afford to hire attorneys, dealing with very difficult legal issues in our courtrooms. As far as the belief that somehow our system is working right now, or that somehow my calling out what's really going on, which we all know is happening, is going to result in some inability to work with people. The fact that my opponent can sit here and say that it's working is the problem. The fact that he can say that there is a recusal rule that's meaningful is a serious problem when you have Justice Gableman sitting on a case where $2.25 million was spent on his race by a party in that case, and he did not step off the case. And my opponent defends that recusal rule, that weak recusal rule that has not been used. He defends it, and he also says that there's no problem with me, there is a problem with me calling the court broken, when it's very clear that special interests have bought justice in our state. They have been buying justices for the last decade, and we need to stop it. Now, why would my opponent think it's okay? Because they're buying him. Because he is sitting here now to the tune of close to $2 million at this point, with different special interest groups, spending that money with an expectation that he will sit on their cases and make decisions that benefit them. That is a problem, and that is something that everyone knows is a problem. And if my opponent thinks calling that out is a wrong thing to do, well, that's part of the problem. Again, I say to him, which he's avoided the question so far, will he recuse himself from the cases where this money is sitting in front of him, this money that's being spent on him right now as we sit here?
The next question for Judge Dallet first. The Wisconsin court was either the only or one of the few to have open conferences. That practice recently ended. Your position on open conferences, Judge?
I believe that conferences should be open. Transparency in government is something that we should all want. It is something that helps people, the regular person in our state, understand what's going on. And we had a wonderful tradition of having rule hearings, the hearings that involve the policy setting in our court, transparent and open, and on WisconsinEye for people to see how that processes worked. They were open until the 55 judges decided to bring a proposal in front of the court in the spring, asking the court to review its recusal rule, stating that this recusal rule is obviously not working and that we need to have a hearing to talk about a meaningful recusal rule, because people in our state don't have confidence in our Supreme Court, our highest court, when people are not stepping off of cases where the money is sitting in front of them. The court at that moment decided not only to shut down the hearing on a recusal rule, but to also shut down those hearings to the public. We need to have a strong recusal rule. That's the policy that I would like to advocate for. I would also advocate for the policy of having those rule hearings remain open again to the public so that everyone can understand how government works and feel that they can participate in it and finally have confidence again in our Supreme Court, a confidence that they have lost.
Judge Screnock, please.
We did have the experiment of open conferences here in Wisconsin, and we were the leader. Wisconsin led in that initiative, and nobody followed. It's my understanding that there's not another state in the land whose highest court holds their administrative conferences, the discussions between the justices about administrative matters, in public. If it was such a great idea, I think at least one other state would have jumped on board, if not a lot of them. I do not have any problem with the court doing the work the way that it is now, and it's important that the citizens in the state understand that the court holds public hearings. The public has the opportunity to provide input and advice on petitions that come before the court on administrative matters. They hold hearings. What they don't do in public anymore is sit as a body and talk amongst themselves about how they view those things. And that's how the court works. The Supreme Court does its work as a body, not as 7 justices. And so when a petition comes in, the court will take input from the public on it. They'll hold public hearings. They then will discuss it behind closed doors, and they will issue a written decision as to what they're doing. That's how the court operates, and I think that is appropriate, and I think it is totally fine. One of the reasons that the public might be lacking confidence in the work of our Supreme Court right now is because of my opponent and the effort she has been on over the last 9 months to urge the voters to disrespect our highest court. But I can tell you that that disrespect would not actually come from a reading of the court's decisions. And again, the court speaks through its decisions. So what is the history? First of all, we have Coyne versus Walker, a case that where a majority of this court, our Supreme Court, found that a legislative act passed by the Republicans and attempted to be implemented by Governor Walker was unconstitutional as applied to the superintendent of public instruction. The business interests have lost every zoning case in the last 2 or 3 years that I can find, and in fact, a large bank lost last Friday in a case that was a decision authored by Justice Gableman. So the notion that these special interests have somehow gotten these justices beholden to their desires and whims is just not borne out by the actual work of the court.
Next question for Judge Screnock first. What could you as one justice or the court collectively do to fight our opioid and methamphetamine crisis?
We have a real crisis in this state, and I don't think it's lost on anyone in this room. I think most people across the state realize that our Attorney General has done a great job in leading the state's efforts in trying to find solutions to that. We have both heroin and methamphetamines that are ravaging our state. They are causing great problems to our human services departments, our foster care system, the criminal justice system, and it is a problem that this state is attacking, and it is one that we will reach some success on slowly. We didn't come at this problem overnight. We're not going to resolve it overnight. Now, the work on the Supreme Court is a limited role when it comes to these things. So the Supreme Court can provide guidance and leadership for the entire court system. The Supreme Court can do what it can to provide support and guidance for our treatment courts and other problem-solving courts across the state. I'm familiar with those. I preside over our treatment court in Sauk County, and I've been the presiding judge since we first started it in January of 2016. And I would continue to work on that fight to the extent that I can as a Supreme Court justice, but recognizing the different roles. Again, it's up to the legislature to make budgetary decisions and determine how to deploy resources. It's important that we understand that that resources that are available to the effort might be better used in the human services and foster care systems rather than within treatment courts. Those are questions for policymakers to make. What the Supreme Court can provide is leadership on the issue, can provide training and education for judges, and can do all that it can to clear the decks for our treatment courts to operate well and efficiently and within the law.
Judge Dallet, please.
I handled a case years ago involving a young girl who died of an opioid abuse given to her by an older man and left to die on a driveway after ingesting the substances. I've been in courts for now 10 years and dealt firsthand with the ravages and the effect of our opioid crisis, not just in criminal court, but in civil court. And it is a methamphetamine crisis as you move out west. I think our courts need to be leaders in this area. Our courts have the ability through the rulemaking authority to also govern issues surrounding our courts, at least to be leaders in that area and to talk about the policies that we want for our courts. That's what those rule hearings are about. That's very different than deciding an issue in a case coming before it, but very important. And our Supreme Court needs to be a leader in this regard. We all need to be talking about how to solve these issues and these problems, and I would be an advocate for that. As far as the example that my opponent gave of a case where the court went one way or the other, there are many examples of the court doing the bidding of the special interest money that has elected the justices in the past decade. One of those cases is the John Doe case, the case where Justice Gableman had $2.25 million spent on his race, and a party sat in front of him in the case. He refused to step off the case and then ruled to shut down that very investigation into the coordination of politics and the money. That now has been changed by the legislature, which is fine, but at the time there was and is a responsibility of a court not to shut down investigations of prosecutors. Anyone here who's known and who's been a prosecutor, as I have, knows that that is something that is unheard of and frankly un-American when you talk about a court shutting down an investigation. I would also point to the MTI open records case where the court felt the need to read into the record information because they didn't have enough. And I think there's plenty more examples where those come from.
Question for Judge Dallet first. Wisconsin has the highest incarceration rate of African Americans. Do you consider that an issue in this election, Your Honor?
Well, I think that mass incarceration is an issue for our state and therefore an issue in everything we do and talk about. We need to absolutely be thinking about ways that we can be smart about making sure that our society is protected, that our communities are protected, but also thinking of ways that we can provide treatment, that we can continue to give that kind of treatment that people need, especially in the areas of the opioid and methamphetamine crisis, and that we can divert whatever resources we have, and we can talk about this. The stakeholders should be talking about this, and to make this something that we can address head on. We can't. We need to face it. We are in a community where we have the highest zip code, the highest amount of incarceration in a zip code in the entire country. And that is something that as a community, all of us need to be talking about. And dealing with racial bias. We know that there is implicit bias. I am a leader when it comes to teaching judges throughout our state. I am an associate dean of our judicial college where we bring issues in front of the other judges, the new and judges going back again, to really talk about issues confronting judges. And this is something that we need to take head on. And I have been taking that head on in terms of really encouraging the discussions that we need to have among judges and the sensitivities that we all need to have surrounding all of these issues.
Judge Screnock, please.
Sentencing decisions are very important. It's one of the most important things that a circuit court judge does. And, you know, it involves restricting somebody's liberty. It involves trying to identify the most appropriate sentence in order to protect our community and keep our communities safe. And sentencing decisions are made on a case-by-case basis. So in terms of whether or not we have a mass incarceration problem here in Wisconsin generally or in the Milwaukee area specifically, that is a question that is being researched, and I appreciate the research that's being done both at Marquette University and the University of Wisconsin. What the Supreme Court can do is continue to, again, allow is to take a leadership role and to make sure that our judges are properly trained, but also to support the research that's being done at our universities. And my understanding is that Chief Justice Rogensack has done that, and she has encouraged that research to be done so that we can see where things stand and whether there's anything that the judicial branch can do differently to help that if there is a problem, but recognizing that sentencing decisions are done on a case-by-case basis by circuit court judges. Now, it's interesting that my opponent, I think this is the first time in this campaign that she has actually acknowledged that the special interests that somehow have bought and paid for a Supreme Court are actually losing cases. And it's important that people hear that, because it's the truth, because it's reality in our Supreme Court. And my opponent has made a lot of hay out of one case, the John Doe case. And she has ignored the host of other cases where it's evidently and abundantly clear that our justices are deciding cases based on the law and not based on their preferences for any parties that come in front of the court. And that is why I do defend our Supreme Court. I defend the work they're doing because I read those decisions. I read them because I'm interested in them, and this is not a broken Supreme Court.
Thank you. This question is from the audience. There's one specific question for each of you. I'll read a question to both of you first. It goes to Judge Screnock first. Judge Screnock, what, if any, promises have you made to Wisconsin Right to Life, the NRA, and other groups who have endorsed you, to Judge Dallet? What, if any, promises have you made to labor unions and Planned Parenthood and other groups who have endorsed you? Judge Screnock, you go first.
Yeah, that's an excellent question, and it's a question that we've answered before. The communication that we had with NRA has actually been published. We released the email. And I think that the reason the question keeps coming up is because for those who believe that there's some boogeyman behind my campaign, they found the email wholly unsatisfying. Because what it disclosed is that I have made the same promise to the NRA that I've made to Wisconsin Right to Life, that I've made to the Wisconsin Realtors Association, that I've made to you here today, that I have made to voters all across the state since the middle of the summer last year when I first announced my campaign. And the promise is this: I am committed to setting aside my personal or political beliefs about any issue or any party and deciding every case based on the law as I find it and not as I wish it to be. I know what that looks like because I worked as an appellate advocate. I shepherded 13 different cases through our Court of Appeals and Wisconsin Supreme Court. And my role was to do the research, to take complex questions of law and do the research and figure out what the law says about those so that we could advocate as best we could for our clients' interests. And when I did that work in every single case, the law provided an answer. And the answer is not, our Supreme Court can do whatever they want because the law is unclear. Now, if a justice wants to be results-oriented, they can, because our justices are very smart. And you can very easily come to the end result first and then come to some path of legal reasoning that will get you there, and it will sound plausible, and people will say, oh, okay. I am committed to not doing that, because I've done the work as an appellate advocate. I know what that research looks like, I know how hard it is, and I know that the task is possible.
Judge Dallet, please.
The only thing we've seen from my opponent with respect to the NRA is a picture, a partial picture of an email that was supposedly sent. I have not seen any letter that's been authored and signed, any original letter. I don't know that one exists, and I don't know what other conversations there were. But someone's not being forthright here. If the NRA is putting out communications saying that my opponent vowed to protect their firearm freedoms, that is not the same thing. That is taking a position and making a promise to them. I don't know what other promises he made to the other groups that he has supporting him. And with respect to the Wisconsin Manufacturer and Commerce, if this is no big deal, if my opponent says he's going to step aside and make sure that he's following the law and not making it look like he's doing the bidding of any special interest group, then he should have no problem telling you here today that he will step aside from any case involving the Wisconsin Manufacturer and Commerce. It does not look fair, regardless of whether you think you can be fair, to have a group that spends $1.5 million on you in cases involving you, and in sitting as a party in a case. And I think that people get that and people understand that. I can talk about other cases too. I started talking about the MTI case. That's a case where the court reached an end result of denying open records to the Milwaukee teachers, reading into the record some kind of suppression of voting that took place when there was absolutely no record of that occurring. And they did that, as Judge Screnock has stated, to really reach that end result that they can do, and everyone will say okay. And I think that that's the kind of justice that he will be. I have made no promises to any groups in order to further my candidacy as a Supreme Court justice.
Another question from the audience, one for each of you. Judge Dallet, it's your turn to go first. In the John Doe case, one newspaper reported that prosecutors kept files on their targets labeled opposition research and tried to criminalize political disagreements. Is that American? That's your question, Judge Dallet. The question for Judge Screnock. Do you think it was appropriate for the Wisconsin Supreme Court to shut down the John Doe investigation? Judge Dallet, you go first.
Okay, and we have different questions being asked of us?
Well,
okay.
Judge D'Amato is my head.
All righty. So I just go back to the John Doe case. I was a prosecutor for 11 years, and I guess I'll answer both our questions. As a prosecutor for 11 years, I understand what it means to be a prosecutor, to conduct an investigation. That is something separate and apart from what a court does. In the case of John Doe, actually the leader of that investigation was someone I worked closely with at the U.S. Attorney's Office when I was there for a few years. Believe his politics are likely Republican, although I don't know for sure. But there were certainly prosecutors on both sides of the aisle that wanted this investigation to go on. It was an important investigation, and regardless of what the outcome would have been, we will never know. It's not the court's job to get involved in a prosecutorial investigation. They've never done it before. To my knowledge, they haven't done it since. And so to have the court in a case where the party, again, that spent all that special interest money electing Justice Gableman was the one that had the real interest in the case and wanted that investigation shut down, and it was therefore shut down, and no one to this day will know. And I do think that that is un-American. And I think that that just shows the kind of influence and power that special interests can have over our Supreme Court, that they have had over our Supreme Court, and that they would continue to have if Judge Screnock is elected to our Supreme Court. His candidacy, his campaign is funded to the tune of hundreds of thousands, over $1 million, close to $2 million at this point. And I don't know, because I haven't seen all the reports yet, but we're pretty close to $2 million. By special interests, not the people in our state, not the people who want their rights protected on our Supreme Court, but by special interests that have an interest in the cases that come in front of that court. And he's going to be the special interest justice that does the bidding of those groups, and that is something that we can all say enough and put an end to that and get back to having a fair and impartial Supreme Court.
Judge Screnock, the question from the audience, was it appropriate for the court to shut down John Doe? Sir?
What the court determined is that what the investigators were investigating was not criminal activity. That they determined that if the investigators found what they were looking for, there was no law violation. And once they made that determination, of course it was appropriate to shut down the investigation. We don't have prosecutors investigating lawful activity. That's not the role of an investigator. The point about sorry, I lost my train of thought. I was trying to pivot, and I didn't do a very deft job of it. What's important about when you consider the recusal issue is that we must have justices that will be impartial, and parties must have justices deciding cases. And so when you look at the participation in this race, I believe fully, I truly believe, if back in June we had 3 candidates who had announced their candidacy for the Supreme Court and all 3 of them said, I am committed to upholding the rule of law, I'm not here to advance any policy matters from the bench, I'm not going to advocate for policy changes, and the only question was which one of us had the best broad base of experience and who would make the best Supreme Court justice, people would not be that interested in this campaign. But what we had was we had 3 candidates, and 2 of them came out of the box. Well, one of them came out of the box, and my opponent actually finally changed her message in December. And by the time the primary came around, we had 2 candidates who were advocating for policy changes and have said that they would do that. My opponent said on Central Time that she would advocate for policy changes. So of course, folks are interested in this campaign, and they are not buying a justice. They are buying, what they are interested in is working on behalf of a campaign in order to ensure that we have justices that will simply follow the law and not advocate for parties or policies.
Thank you. It's time for closing statements. There was a coin toss, and Judge Screnock is going to go first with a 1-minute closing statement, followed by Judge Dallet.
All right, thank you. Once again, I want to thank everyone for being here. This is really an important race, and it's important because the voters across the state have a very clear choice in this election. And the choice is between my candidacy, and I am absolutely committed to setting aside any personal or political beliefs I have about any party or any issue, and deciding cases based solely on the law. That's why I've received the endorsement of a bipartisan majority of sheriffs, over 2/3 of the sheriffs of the state. I've received the endorsement of the business community, represented by Wisconsin Realtors Association, the Wisconsin Restaurant Association, the Dairy Business Association, and I have received the endorsement of groups that are concerned about social issues, political action committees of Wisconsin Right to Life, Pro-Life Wisconsin, Wisconsin Family Action, and the National Rifle Association. And here's why. Because they understand that we need stability and predictability in the law that we only have when we have justices who will simply uphold the rule of law, do the research, go where the law takes them, and not be partisan activists. I am committed to being an impartial justice, and I would be honored if you would vote for me on April 3rd.
Thank you. Judge Dallet.
This is a critical time in our nation's history. Our institutions, those that have held up our great democracy for more than 200 years, are under tremendous assault. Special interests, which many of our founding fathers warned us against, have huge power. I'm running to change that. What we've heard today is a political figure spouting the same tired talking points to appeal to the far right wing and further politicize the judiciary as Scott Walker's rubber stamp. My opponent is bought and paid for by the big-moneyed special interests that have had far too much influence on our state's highest court in recent years. I have served Wisconsin for more than 20 years, helping victims, prosecuting criminals, and upholding the law. During my 10 years as a judge, I've heard over 11,000 cases, over 230 jury trials, and put my values to work. It's time we bring back Wisconsin values of independence and fairness, and that's just what I'll do as your next Supreme Court Justice. I'd appreciate your vote.
Before Judge D'Amato closes, I just want to thank you on behalf of WisconsinEye for letting WisconsinEye participate. Your Honor.
As we bring this forum to a close, I have 4 very important thank yous and 3 very important reminders. First of all, I want to thank Steve Walters for moderating today. He does a fabulous job, and we were honored to have him here today. I also want to thank our 2 candidates, Judge Dallet and Judge Screnock, for being here and for submitting themselves to cross-examination. I want to thank all the members of the audience, particularly the Milwaukee judiciary who are here today. The Milwaukee Bar Association has done a lot for this community and has done a lot for the judiciary in this state, and we thank them. Specifically, Katie Borowski and her staff. They do a fabulous job of putting on this forum every year, so we thank the Milwaukee Bar Association and particularly Katie. With respect to reminders, if you are a Milwaukee Bar Association member, remember the annual judicial poll closes today at 5 o'clock. So if you haven't answered the poll, and it's all done electronically, you still have time. Please do that. That's very important. Second of all, this comes as a shock to nobody. The election is next Tuesday, April 3rd. Please remind your family members, your friends, anybody you come into contact with, that April 3rd is the spring election. And this is a very important election. All elections are important, but this is really, really important. If people really care about their community, if you care about your courts, if you care about government, you should vote. Voting is not just a right, voting really is a duty if you care about your community. So thank you all for being here today, and this brings our judicial forum for 2018 to a close. Thank you.